The bench of the Court of Appeal constituted to hear the appeal against the High Court ruling that nullified the BBI constitutional amendment process has begun the four-day hearing. The Attorney General and the BBI Secretariat today presented their submissions in an open court at the Supreme Court Gardens. The two appellants arguing their case in their attempt to salvage the BBI bill. And as Musa Salah now reports, the two appellants seem to agree on the BBI bill's interference with the basic structure doctrine of the Constitution, which the High Court said cannot be changed.
Yes, President, I'm just curious.
Armed with the piles of files and papers, the four appellants in the appeal against the 13 May High Court ruling that declared the BBI constitutional amendment process unconstitutional flocked into the open court at the Supreme Court Gardens.
It does not exist.
First on the stand before the BBI Secretariat argued their case was the Attorney General's team that raised 31 grounds of appeal, including the structure of the Constitution, in which the five-judge bench of the High Court based their judgments on, claiming that the BBI would change the structure of the Constitution.
It is an item of jurisprudence that some, what I would call New Age scholars, are trying to urge on the world to say that there should be some limitation to be decided by the judiciary on when people or what people can amend in a constitution. These concepts are not being employed elsewhere. In fact, our own neighbors have rejected it. Uganda has rejected it. Tanzania has rejected it. Every African Supreme Court has rejected it. For some reason, Kenya has decided it is okay.
The trial court, because they were so anxious about applicability of the basic structure doctrine, they had to create it. They had to invent it, because nowhere does it exist in the Constitution.
The High Court decision to throw the BBI bill out of the window on grounds that the BBI bill was initiated by the President and thus not public-driven seemed to have irked the senior counsels. According to the two appellants, the five judges denied President Kenyatta his individual political right as a Kenyan to initiate a public initiative.
And the point that I was making is that, in fact, the people have an option of going to Parliament through Article 119. So both the President and the people can access Parliament in that sense.
Now, Mr. Garuri, under Article 257(2),
yes,
a popular initiative for amendment,
yes,
may be in the form of a general suggestion or by way of formulated as a bill. Do you see a situation where those who wield state power can make a general suggestion? To whom are they making that general suggestion?
My Lord, I do not want to hypothesize, but I can, even when you are talking about the general citizen, the Wanjiko, when they come up with a general suggestion, to whom would they be making that general suggestion?
To the Parliament, to the county assemblies, etc., to government, to the state. Yes.
And my Lord, the President can make a general suggestion or can make a suggestion
to his government,
to the people, to consider an amendment to the Constitution. Right. They can make a general suggestion.
The Elections Act gives the President actually the power to come out with an issue to be taken to the people and a referendum held.
The lawyers argue that the five judges erred in law by recommending that separate questions should have been placed for separate issues in the BBI bill if the bill was passed and a referendum held.
And have replied in this court as such respondents.
Lawyer Charles Kanjama, who petitioned that the Independent Electoral and Boundaries Commission IEBC's signature verification exercise was flawed, was thrown out of the appeal, the court having declined his plea to participate in the case.
The quorum to pass constitutional master will just be the same number.
No, my Lord, there's actually a maximum number, which is 9.
Yeah,
so
exactly.
For purposes of conduct of the business, if there are 9, that's fine. But my Lord, the point that I'm making is simple. The Constitution says each commission shall consist of at least 3. but not more than 9 members.
So if you have 9 members
Yes.
in a commission,
Yes.
you're saying so long as there are 3, that is a quorum.
My Lord, my position is that as long as a commission has a minimum of 3, it is entitled to conduct the business of the commission.
Okay.
Yes.
The hearing is expected to continue on Wednesday as the IEBC and President Kenyatta's legal team prepare to submit their submissions. Musa Salah, TV 47.